Hello and welcome to BYJU'S IAS. Welcome to lecture number 2 of Polity-based current affairs. But before we start, very briefly for those who are joining in us for the first time, we hope to cover current affairs of the past 1 year subject-wise. Polity-based current affairs, international relations-based current affairs, economics-based, environment and ecology, science and technology, one live session for various government schemes, one live session for various reports and indices. That's number 1. Number 2, what else can you expect from these live sessions? Number 1, we are going to provide you with a question bank. Lots and lots of MCQs which can help you in your last minute revision. Also, the PPTs that we shall be using, you can always download them. The link is provided in the video description below. Also, these sessions, you would know, we have disabled the live chat, primarily because of the fact that we don't want you to interact with each other. We want you to focus on the class and on the smart board. And also, you would know that these classes are not free. You will have to pay us, and you'll have to pay in the form of likes, comments, subscribe to our channel if you haven't yet, and share the links of these live classes with your friends and fellow aspirants. Let's get started, but first up, COVID-19. COVID-19 pandemic. What sort of question can be asked in Indian polity from COVID-19? For that, we need to understand something, and that is, India is a federal polity. But what do we mean by federalism? The problem is, there is no definition of federalism. We don't know what is a federal constitution. Then what do constitutional experts do? What they do, they compare a constitution with the Constitution of United States of America, which is considered to be the oldest federal constitution of the world. It was adopted at Philadelphia. The year was 1787. It came into force in 1789. So we say US Constitution is the oldest federal constitution of the world. And what these constitutional experts do, they take a look at a constitution and compare it with the US Constitution. If it matches the US Constitution, it is federal. If it does not match the US Constitution, it is something else, it is not federal. But what are these characteristics that make US Constitution a federal constitution? There are 5 important characteristics, and definitely you should expect this question in your Prelims 2020. At least if I was the question paper setter, I would include this question to test your conceptual clarity. What are these 5 ingredients that make US Constitution a federal constitution? Number 1, dual government. Government at the center, government in every state as well. Number 2, distribution of powers. Some powers are given to the center, some powers are given to the states, clear-cut distribution of powers, so that one organ does not interfere with the affair of another state. Third, supremacy of the Constitution. Constitution is supreme, and every law that a state legislature passes or every law that a central legislature passes, it has to be in conformity with the Constitution. It has to be in agreement with the Constitution. Constitution has to be supreme. Fourth, Constitution should also be rigid. Now please understand, rigidity does not mean Constitution cannot be amended. Rigidity also does not mean that it is very difficult to amend the Constitution, change the Constitution, modify the Constitution. No. Rigidity means that if Constitution is to be amended, modified, it must be the joint act of both. Both center as well as the states must come together to change, modify, amend this Constitution. That's what rigidity means. And number 5, judiciary should be independent. Judiciary should not tilt in favor of the center, should not be biased in favor of the states or the center. Judiciary should be independent. These are the 5 ingredients that make US Constitution a federal constitution. What about Indian Constitution? Is it federal? We have dual government. One government at the center, government in every state as well. Do we have distribution of powers? Yes. Article 246 of the Constitution, it talks about Schedule 7. It talks about distribution of powers. Some powers are given to the center. For example, defense, external affairs, communication, banking, insurance, citizenship. These are under the exclusive domain of the parliament, of the center, of the union legislature. States do not have the power to make laws on these subjects. Then we have state list. Some powers, some subjects are given to the states as well. For example, law and order, land, agriculture, police, gambling. These are the powers that are given to the states. And then we have list 3, and that is what we call concurrent list. And all those items that are mentioned in the concurrent list, both the center as well as the states, they have the power to make laws on these subjects. For example, marriage, divorce, criminal procedure, civil procedure. That means clear-cut distribution of powers. Is our constitution supreme? Yes. Is our constitution rigid? You would recall when GST was implemented in this country, GST bill was passed by the parliament, both houses of the Indian parliament, but unless and until when all the states, more than half of the states in India, they accepted approved GST bills, only then GST could be implemented in this country. That means there are some items in Indian system where if you want to change the constitution, both center and the states, they have to come together to change the constitution, modify the constitution, amend the constitution. And is our judiciary independent? Absolutely yes. So if these are the 5 characteristics that makes US Constitution a federal constitution, these characteristics are found in Indian Constitution as well. In fact, Supreme Court has said that federalism is part of the basic structure of Indian Constitution. But some dispute. Some say Indian Constitution is not federal. They say Indian Constitution is unitary. Or there is one specific term that we use for Indian Constitution, and that is quasi-federal. Indian Constitution is not completely federal, is not completely unitary. It is quasi-federal in its characteristic. But we have to abide by the Supreme Court. Supreme Court says Indian Constitution is federal. So if Indian Constitution is federal, why is Prime Minister Modi addressing the nation and announcing a lockdown, that too in a state? Why is MHA, Ministry of Home Affairs, announcing green zones, orange zones, red zones when it comes to containment of COVID-19? It is in this light that COVID-19 plays a very important role for your examination. Some say because of COVID-19, our federal constitution has transformed itself into a unitary constitution. Let's look at the question. Question number 1. In the context of COVID-19, which of the following statement is or are correct about center-state relations? Under the Epidemic Diseases Act of 1897, the central government is not empowered to issue directions to the states to contain the pandemic within the state. Is the statement correct? Absolutely correct. Under this Act of 1897, central government can issue a directive to a state only to contain the pandemic, which is interstate. Only to contain the pandemic so that it does not transfer from one state to another state. This statement is absolutely correct. Statement number 2, what about Disaster Management Act? This term, disaster management, does not find mention in the state list, concurrent list, and the union list. Is it correct? Absolutely correct. Disaster management word is not mentioned anywhere in the Constitution. So which of these statements are correct? Both. C is the correct answer. Also, something else happened. An ordinance was promulgated by the president. An ordinance can be promulgated by the president under Article 123 of the Constitution. What was this ordinance? We saw because of COVID-19, there were multiple attacks, unfortunate attacks on doctors, on the paramedics, and then an ordinance was promulgated by the president. This ordinance says violence against healthcare personnel fighting COVID-19 pandemic will be treated as cognizable offense as well as non-bailable offense. What is a cognizable offense? If I am booked under cognizable offense, a warrant by the magistrate is not needed, the police can arrest me. That means cognizable offenses are those offenses under which I can be arrested by the police without magistrate having to issue an order, having to issue a warrant. That is what we call a cognizable offense. And it is also a non-bailable offense. So when we look at COVID-19 pandemic and an ordinance was promulgated by the president under Article 123, you may be asked question about ordinance as well. What is this ordinance? Article 123 states, President can promulgate an ordinance. How? If either one or both houses of the parliament are not in session. Remember this statement carefully. President can promulgate an ordinance only if either one or both houses of the parliament are not in session. That's when president can promulgate an ordinance. One important thing, ordinance cannot be promulgated to amend the constitution. That means constitution has not given the power to the president to promulgate an ordinance and amend the constitution. No, constitution can be amended only by following the procedures mentioned under Article 368 of the Constitution. So you may be asked question on ordinance as well. And I'll give you one more statement. President can promulgate an ordinance if either one or both houses of the parliament are adjourned. Is this statement correct? This statement is incorrect because adjournment does not terminate the session of Indian Parliament. No, adjournment only is a brief interval in an ongoing session. The session does not end because of adjournment. Session ends because of prorogation. So if the statement is President can promulgate an ordinance if either one or both houses of the Indian Parliament are prorogued, under that situation, President can promulgate an ordinance under Article 123 of the Constitution. So important thing about ordinance as well. Another interesting thing. What is the maximum validity of an ordinance? The maximum validity of an ordinance is 6 months plus 4 weeks, which is primarily 7.5 months. So the maximum validity of an ordinance is 7.5 months. This can also be asked in your examination. Let's look at something else. Disaster management, if it is not mentioned in either union list or state list or concurrent list, then how was this Disaster Management Act passed in the year 2005? Under what powers? And that is what we call residuary power. What is residue? Leftover. If there is an item which is neither mentioned in union list, nor state list, nor concurrent list, who has the power to make law on that residue? This residuary power is given to the Parliament of India. And that is how in 2005, Parliament enacted a law, Disaster Management Act. Interestingly, this residuary power in United States Constitution is given to states, not to the center. You have one topic in your syllabus, comparison of the world constitutions. So here we are comparing US Constitution with the Indian Constitution. And it is under this residuary power that Parliament enacted Disaster Management Act in the year 2005. And it is this Disaster Management Act which was used by the center to issue directives to the states, to issue guidelines to the states, to talk about these orange zones, red zones, green zones. That's very important statement. Another one, if COVID-19 is related to public health, but public health is a state subject. In the distribution of powers, public health and sanitation is under the control of the states. It's under state list. So this statement in verbatim can be asked in your prelims examination. And then if there is a concern that a disease is contagious and it can spread from one state to another state, who has the power to make law on that subject? It comes under concurrent list. This statement is again very, very important. If both parliament as well as state legislatures, they want to come together and contain the spread of contagious diseases, that is within their domain, because this comes under concurrent list. These are very important statements and you must expect a question on these items. Let's look at something else. Now we are going to talk about union executive and union legislature, and let's see what sort of questions can be asked in the examination. But why was union executive and union legislature in the news? Because of various cabinet committees, because of Anglo-Indians as well, and we will discuss all of them one by one. First up, which of the following statement is or are correct regarding Council of Ministers? Statement number 1, Constitution of India has fixed the maximum size of the council. Yes, but original constitution did not fix the number, did not fix the size, did not fix the strength of Council of Ministry. It was only in the year 2003, Atal Bihari Vajpayee was the Prime Minister, Constitution was amended, 91st Constitutional Amendment Act was passed, and a number was fixed. And now the strength of Council of Ministers, including the Prime Minister, shall not exceed 15% of the strength of Lok Sabha. That means original constitution did not fix the number of the Council of Ministers. How many ministers could be there in the cabinet or in the Council of Ministry? This number was fixed in the year 2003. Statement number 2, the council is collectively responsible to the Prime Minister. Absolutely wrong. And this is where another interesting concept comes in. And this is the question that was asked in your 2015 prelims examination. Parliamentary democracy. What is parliamentary democracy? Council of Ministers are accountable to Lok Sabha. They are not accountable to the Prime Minister. In fact, individually also, ministers are not accountable to Prime Minister. Individually, they are accountable to the President of India. So this statement number 2 is incorrect. Statement number 3, it is the duty of the Prime Minister to communicate to the President all decisions of the Council of Ministers. Since the former President Pranab Mukherjee died, what are the powers of the President? That may also be asked in your examination. So statement 3 is absolutely correct. So what is the right answer? 1 and 3. B is the correct answer. Let's look at something else. The Union Home Minister is presently heading which of the following cabinet committees? Mr. Amit Shah, all dominant in the governance affairs, unfortunately was also detected COVID positive. Wishes for a great health ahead. Home Minister is in the news, COVID-19 is in the news, cabinet committees are also in the news. So Home Minister currently is heading which of the following cabinet committees? And I'll tell you, there is an absolutely good link with current affairs. Parliamentary Affairs Committee? No. Very importantly, till recently, this Parliamentary Affairs Committee used to be headed by the Home Minister. So Home Minister would head Parliamentary Affairs Committee. But now this Parliamentary Affairs Committee is headed by the Defense Minister, Mr. Rajnath Singh. It is not headed by the Home Minister. Economics Affairs Committee? No. It's headed by the Prime Minister. Political Affairs Committee? No. Headed by the Prime Minister. In fact, this Political Affairs Committee is also known as Super Cabinet. Appointments Committee of the Cabinet? No. This is headed also by the Prime Minister himself. Cabinet Committee on Accommodation? Yes. This is the only cabinet committee which is headed by the Home Minister. So B is the correct answer, 5 only. And why is this cabinet committee on accommodation in the news? Priyanka Gandhi Vadra. She was an SPG protectee, protected by Special Protection Group, and she was asked that you please vacate the bungalow that the central government allotted to you, and she ultimately did. But this decision, who takes this decision? Cabinet Committee on Accommodation. So all this real estate, the flats, the bungalows that the central government has, who gets to occupy these flats and bungalows, who takes that decision? That decision is taken by Cabinet Committee on Accommodation, and this Cabinet Committee on Accommodation is headed by the Home Minister. So this Cabinet Committee, Priyanka Gandhi Vadra, that's the link of current affairs. But what about SPG? Let's look at this very important question. According to a recent amendment, because this was also amended recently, according to a recent amendment in SPG Act, the force now protects the Prime Minister and members of his immediate family only if they are residing with him at his official residence. Absolutely correct. This was because of the recent amendment to SPG Act. So statement number 1 is correct. Statement number 2, it will also provide security to former prime ministers and their immediate family members staying with them at the residence allotted for a period of 5 years from the date on which they cease to hold the office. Prior to this amendment, this SPG protection was accorded to former prime ministers and their family members for a year. Now this period has been changed to 5 years. So even this statement is correct. Statement number 3, if the SPG security is withdrawn from a former prime minister, it will also be withdrawn from his immediate family members. This statement is also correct. And currently, Prime Minister Modi is the only individual, is the only constitutional functionary to be provided security by SPG. So all these statements are correct. D, all of the above is the right answer. Let's look at something else. Last year, 2 more cabinet committees were constituted. Let's look at these cabinet committees. These cabinet committees are not mentioned in the Constitution. Constitution does not talk about these cabinet committees. In fact, very interestingly, even this word cabinet was not mentioned in the original Constitution. This word cabinet, very important statement, was not mentioned in the original Constitution. Then how was this word added to the Constitution? You would recall 1975. Mrs. Gandhi, Indira Gandhi was the Prime Minister. She recommended to the President that please impose national emergency in this country. It is widely believed that the President was in his bathtub when Prime Minister Gandhi recommended national emergency. And President imposed national emergency, issued a proclamation, and national emergency was imposed in this country. But the curious case is, Cabinet was not consulted. It was the individual advice of the Prime Minister to the President. It was the oral advice called the President, oral advice to the President that please impose national emergency. And President did that. Next morning, at around 6 o'clock in the morning, a meeting of the Cabinet was convened by the Prime Minister. And there she is informing the ministers that emergency has been imposed. So emergency was imposed in 1975 because of the oral advice of the Prime Minister. And that's what happened in 1975. And then in 1978, Constitution was amended for the 44th time. 44th Constitutional Amendment Act. The year was 1978. And the principal objective of this act was to prevent the misuse of Prime Minister, to prevent the misuse of national emergency. And it is because of this 44th Amendment that the word cabinet got added for the first time. Now, 44th Amendment says if tomorrow President has to issue a proclamation, President has to promulgate national emergency, it has to be only on the written advice of the Cabinet. So Cabinet word originally was not part of the Constitution. It was added to the Constitution by 44th Constitutional Amendment Act. The year was 1978. And in fact, these cabinet committees also, They are extra constitutional entities. They are not mentioned anywhere in the Constitution. How many cabinet committees can be there? This is the prerogative of the Prime Minister. When Dr. Manmohan Singh was the Prime Minister, there were about 13 cabinet committees. During the first term of Prime Minister Modi, there were about 6 cabinet committees. And last year, 2 more cabinet committees were added. So right now, the number is 8. There are 8 cabinet committees currently. 2 more cabinet committees were added, and I'm going to tell you slightly later which are these 2 cabinet committees. But first up, let's look at the question. The question is, the newly constituted Cabinet Committee on Investment and Growth. This is the new Cabinet Committee, the 7th one. It will review economic trends and frame an integrated economic policy. This statement is incorrect. Why? Because this is not the domain of this new Cabinet Committee. This power to review the economic trends, frame an integrated economic policy, this power is given to Cabinet Committee on Economic Affairs. It is not given to Cabinet Committee on Investment and Growth. Statement number 2. Cabinet Committee on Employment and Skill Development is newly constituted to reap the benefits of demographic dividend. Absolutely correct. Which of the following statements are correct? B, 2 only. Demographic dividend. Majority of our population is below the age of 30. It is argued that if we are not in a position to train these young people, the young population that we have, our demographic dividend can turn into a demographic nightmare. And for that, the youth of this country must be empowered. They should not only seek jobs, but they should be creators and enablers of the jobs as well. And that is going to be the mandate of this Cabinet Committee on Employment and Skill Development. So this statement 2 is correct. Let's look at something else. With reference to cabinet committees, consider the following statements. They are constitutional bodies. Now you would know this statement is incorrect. They're not provided by the Constitution. The committees will be dissolved in coterminous with the Lok Sabha. No. Even if Lok Sabha is dissolved, even if there is a next government in place, these cabinet committees will still continue. But it is for the Prime Minister to decide whether these cabinet committees can be enhanced or they can be restricted. But their life and death is not dependent upon the life and death of the Lok Sabha. So statement 2 is incorrect. Non-cabinet ministers also can be members of the committee. This statement is correct. Although the term is cabinet committee, normally we would say that only the cabinet minister would be the member of these cabinet committees. But this statement is not true. Non-cabinet ministers are not barred from their membership. That means non-cabinet ministers can also be made members of these cabinet committees. Let's look at something else. Former President Pranab Mukherjee died. Let's look at the question. Even though the President of India is not a member of either house of the Parliament, he is an integral part of the Parliament because, first up, what is the composition of an Indian Parliament? We say Indian Parliament consists of President, Lok Sabha, as well as Rajya Sabha. So President is part of Union Executive, President is part of Union Legislature as well. Parliament consists of President, Rajya Sabha and Lok Sabha. So if President is not a member of Lok Sabha or Rajya Sabha, we still say President is an integral part of the Parliament. Why? Let's look at the 4 options. Option 1, without his recommendation, any bill can't be introduced in either house of the Parliament. No. There are only 3 bills which require prior consent of the President. Without prior permission of the President, these 3 bills cannot be introduced in the Parliament. Which are these 3 bills? Number 1, a money bill under Article 110 of the Constitution, financial bill under Article 117 of the Constitution, and an ordinary bill under Article 3. And what is this Article 3? It talks about reorganization of the states. So that is how Andhra Pradesh was reorganized. Jammu and Kashmir was reorganized when a bill was passed under Article 3 of the Constitution. These are the only 3 types of bills which cannot be introduced in the Parliament without the prior consent of the President of India. Apart from that, any bill can be introduced in the Parliament even without the prior consent of the President of India. So statement 1 is incorrect. Statement number 2, he is the final authority to decide the disqualification of candidates under anti-defection law. This statement is incorrect. Who gets to decide whether a member of the Parliament or member of the state legislature can be disqualified under anti-defection law? Anti-defection law is in the news because of what happened in Karnataka, what happened in Madhya Pradesh, what happened in Karnataka, what happened in Rajasthan recently. Anti-defection law is in the news, but the speaker gets to decide. The speaker of the Lok Sabha, the chairperson of Rajya Sabha, the speaker of the Legislative Assembly of the state, they get to decide whether an individual legislator can be disqualified under anti-defection law, not the president. Statement number 3, the bill passed by the Parliament cannot become a law without his assent. This is correct. That means a bill should be passed by the Parliament, and Parliament includes President, Lok Sabha as well as Rajya Sabha. So when a bill is passed by Lok Sabha, then passed by Rajya Sabha, or a bill is first passed by Rajya Sabha, then passed by Lok Sabha, then it must be sent to the President. And it is only when President signs this bill, gives his assent to the bill, that the bill becomes a law, the bill becomes an act, it becomes the law of the land. And that is why we say President is an integral part of the Parliament, because without his assent, no bill can become law in this country. Statement number 4, he can increase or decrease the size of both houses of the Parliament. Absolutely wrong. C is the correct answer. Let's look at something else. MPLAD scheme. An MPLAD scheme, you would know, was also in the news because MPLAD scheme has been suspended now because of COVID-19 pandemic. What is this MPLAD scheme? Members of Parliament Local Area Development Fund or Local Area Development Scheme. I am a legislator. Let's say I am the member of the Parliament. I belong to Lok Sabha, for example. Under MPLAD scheme, I have the power that I can recommend works to the tune of 5 crore rupees. Every year, I can recommend works to the tune of 5 crore rupees. I can ask the district authorities, please construct a road, please construct a school, please construct a dispensary. And the money from MPLAD scheme should be spent for these purposes. Very important statement here. This money is not given to a member of the Parliament. No. I can only recommend works. That means this money is not deposited in my account. I can only recommend work and ask the district authorities, please implement these works to the tune of 5 crore rupees. And that is what MPLAD scheme is all about. Look at the question. Which of the following statements is incorrect? Incorrect about the MP Local Area Development Scheme. Each MP is entitled to 5 crore per annum under the MPLAD scheme. Absolutely correct. That's what I told you. Statement 2, the funds released under the scheme are non-lapsable. This is correct. These funds do not lapse. Even if you don't spend this money, it won't lapse. Statement number 3, the nominated members of Rajya Sabha can recommend works for implementation anywhere in the country. If, for example, I am the member of Lok Sabha, I am the representative of Varanasi constituency, I can recommend works from this MPLAD scheme in Varanasi. If I am a member of the Rajya Sabha, let's say I am a member of Rajya Sabha from the state Assam, I can recommend works only in Assam. But if I'm a nominated member of Rajya Sabha, I can recommend works anywhere in this country. Anywhere in this country. Statement number 4. Recently, the government suspended the MPLAD scheme. Half of the statement is correct. That's what I told you in the beginning. MPLAD scheme has been suspended. But so that the amount saved can go into the PM CARES fund. PM CARES fund in the news. So the moment you look at this phrase, this name, PM CARES, you would assume that this statement is correct. But this is the incorrect statement. This money will not go into the PM CARES fund. So statement D is incorrect. This is the right answer. Let's look at PM CARES then. What is PM CARES? Which of the following statement regarding Prime Minister's Citizen Assistance and Relief in Emergency Situations Fund, PM CARES, is or are correct? Number 1, to undertake and support relief or assistance of any kind relating to a public health emergency or any other kind of emergency, calamity or distress, except man-made disasters. Half of the statement you would have read, but now you are confused whether man-made disasters are excluded or only natural disasters are included. That is why you have to be absolutely sure about this. That is why revision is the key to success in this examination. Except man-made disasters, no, including man-made disasters. Whether these are man-made disasters or natural calamities, we can spend money from PM CARES. Statement 1 is incorrect. The fund consists entirely of voluntary contribution from individuals, organizations, and does not get any budgetary support. This statement is correct. No budgetary support will be given to PM CARES. It's only because of the individual donations, individual contributions that you, me, or other corporates can donate to this PM CARES. So statement 2 is correct. Statement number 3, donations to PM CARES, they will be treated as and qualified as corporate social responsibility expenditure under the Companies Act of 2013. This statement is also correct. That is why, if you recall, there was a controversy and then there was a Supreme Court judgment as well. The controversy was that if we already have a National Disaster Response Fund, NDRF, why do we need another fund which is PM CARES? NDRF already has a lot of money. So why should we have PM CARES? The money that NDRF gets can be given to the states as well. But the money that is in PM CARES cannot be given to the states. So why should we have PM CARES when we already have NDRF? On top of that, there was another controversy. It was argued that since more and more people, organizations, they are donating to PM CARES, there should be audit of PM CARES, and that too by Comptroller and Auditor General of India. We now have a new CAG, GC Murmu. GC Murmu was the Lieutenant Governor of Jammu and Kashmir. Then he was transferred, he resigned, and then he was appointed by the President as the Comptroller and Auditor General of India. So CAG is in the news, PM CARES is in the news. Let's combine the two. So the allegation was that since more and more money, more and more funds have been donated to PM CARES, why should there not be an audit of this PM CARES fund, that too by CAG? But the Supreme Court rejected this. Supreme Court said PM CARES is primarily a public charitable trust, and if it is a charitable trust, a private capacity, why should CAG audit this PM CARES? No audit will take place. On top of that, people also say that more and more prominence, more and more publicity is given to PM CARES, more and more publicity is not given to NDRF. So these were the allegations, counter allegations, controversies surrounding PM CARES, and this can be asked in your prelims examination. Statement 1 is incorrect. Statement 2, 3 is correct. So what is the correct answer? C. Only 2 and 3 is the correct answer. Let's look at something else. PM CARES is in the news. What is the composition of PM CARES? We say Prime Minister will be the ex officio trustee or chairperson trustee of this PM CARES fund. And who are the other members or other trustee members of PM CARES? Minister of External Affairs? No. Minister of Home Affairs? Yes. Minister of Finance? Yes. Minister of Defense? Yes. That means 1, 3, 4, 5. C is the correct answer. So you have to be absolutely sure that Minister of External Affairs, Mr. S. J. Shankar, he is not the trustee member of PM CARES fund. Be absolutely clear about this. Let's look at something else. Attorney General for India. Normally, how do we use this phrase? Attorney General of India. But it is not Attorney General of India. It is Advocate General of State, but it is Attorney General for India. There's a beautiful article written on the wire.in and which clearly talks about Attorney General for India. Why is Attorney General in the news? Reason number 1. Attorney General Mr. Venugopal, his term has been extended for another 1 year. President issued an order and presidential order said Mr. Venugopal is to be appointed as the Attorney General for India for a period of 1 more year. That's why it is in the news. It is also in the news because of Prashant Bhushan case. Prashant Bhushan was convicted by the Supreme Court for contempt of court because through his tweets, he scandalized the judiciary, scandalized the Supreme Court. But when the argument was going on in the court, Attorney General made a passionate plea to the Supreme Court. Attorney General Mr. Venugopal said, I urge you, you have now convicted Prashant Bhushan for contempt, but please do not punish him. Please do not punish him because he has done a lot of public good. And it is for that reason he should not be punished. That's why Attorney General for India is in the news. Also in the news because of actor Swara Bhaskar. Swara Bhaskar made few statements, presumably against the Supreme Court, and that is why there was an individual who filed a contempt of court case against Swara Bhaskar. But this contempt of court, as we have discussed yesterday, this case cannot be filed in the Supreme Court unless and until either the Attorney General for India or the Solicitor General for India of India gives written permission. An Attorney General decides that no contempt of court case should be filed against Swara Bhaskar. That's why Attorney General for India is in the news. But who is this Attorney General for India? Let's look at some of the very important statements, very important facts related to Attorney General. Number 1, Attorney General of India is appointed by the President. Number 1, he can be removed by the President as well, or he can submit his resignation. That means he can resign by submitting his resignation to the President as well. Interesting thing is, he does not have a secure tenure. That means Constitution has not prescribed the tenure for Attorney General for India. Can be appointed for a year, can be appointed for 3 years, and normally Attorney General for India is appointed for a period of 3 years, but this term is not mentioned in the Constitution. Please be absolutely clear about this. Also interestingly, this Attorney General for India, he has some powers, he has some privileges, he has some unique privileges that Constitution provides him. What are these privileges? Number one, Attorney General, we say, is the first law officer of the country. What do we mean by first law officer of the country? Who is the biggest litigant in India? Biggest litigant in the sense which files the highest number of cases and against whom the highest number of cases are filed. That's the union. That means union government. And there has to be someone who is going to present to the judiciary the side of the union, who is going to defend the union in the Supreme Court and various courts in this country. And that individual is Attorney General for India. That's one important thing. Second, he plays a very important role under Article 143 of the Constitution. What is Article 143? Under Article 143, Supreme Court acts as the advisor of the President. And this is the power which is not available to a US President. This is a unique power that Constitution has given to the President of India. Under Article 143, Supreme Court acts as the advisor of the President. President can refer any matter to the Supreme Court, asking the views of the Supreme Court on that matter. Let's say, for example, few years ago, when Dr. Manmohan Singh was the Prime Minister, 122 2G licenses were cancelled by the Supreme Court. Supreme Court said, no, this process which you have followed to give licenses, 2G licenses, it is flawed. Then the President used the power under Article 143 and asked the Supreme Court, please advise me, how do we give spectrum? Or how do we give natural resources? How do we sell natural resources? Supreme Court said, better way is go for auction. Auction the resources, auction the spectrum. That's how you should allocate spectrum to these individuals, to these organizations. And when hearing this case, who takes the stance of the President of the Union? That's the Attorney General for India. He plays a very important role when the Supreme Court is hearing this presidential reference. And while hearing this presidential reference, Attorney General for India, he has a very, very important role to play. Interesting privilege is this, and this is where we can link it with current affairs as well. As Attorney General for India, he has a privilege, and that privilege is he has the right of audience. Very important statement. If I was the paper setter, I would include this question. What is this right of audience? That means Attorney General for India, he can walk into any court in this country and no court in this country can deny hearing Attorney General. That means every court in this country has to hear Attorney General for India. Why is this in the news? Prashant Bhushan, when he was to be convicted by the Supreme Court, because through his tweets he scandalized the judiciary. He also had tweeted that there was a 2009 case. Way back in 2009, Prashant Bhushan had given an interview to a Tehelka magazine. And therein he had said that previous chief justices were corrupt. And now court was hearing this 2009 contempt of court case against Prashant Bhushan. And when this case was heard, Attorney General stood up and said, "Dear Supreme Court, please hear me. I know which previous chief justices said that judiciary is corrupt. Please hear me." Justice Arun Mishra was presiding over the Supreme Court bench. He said, "No, Mr. Attorney General, we cannot hear you on merits." That means this privilege, that Attorney General has the right of audience in any court in this country, this privilege was snatched from Attorney General by the Supreme Court. That is why this is in the news. That means as the Attorney General for India, he has a privilege wherein he has the right of audience anywhere in this country, in any court in this country. He has another privilege. He is given the rank of a cabinet minister. He can also come, sit in the parliament, speak in the parliament. That's his privilege. He can also become a member of a parliamentary committee. He can also and speak in a parliamentary committee, except one thing. He does not have the right to vote. Why Attorney General for India does not have the right to vote? Because he is not the member of the parliament. But he has a privilege. He has the right of audience in all courts in this country. He can come in the parliament, speak in the parliament, be part of the parliamentary committees, but he cannot vote in these parliamentary committees because he is not the member of the parliament. But Attorney General for India is the member of Union Executive. We discussed that Parliament consists of President, Rajya Sabha and Lok Sabha. Union Executive consists of President, Vice President, Prime Minister, Council of Ministers and Attorney General for India. That means Attorney General for India is part of Union Executive. That is what you need to know regarding Attorney General for India. You can expect a question on Attorney General for India. Let's look at something else. Right now, there is another controversy, and that is surrounding question hour. Question hour has been suspended when the Parliament is about to meet. What is this question hour? What sort of questions can be asked on question hour? Let's discuss these questions. Number one, prior to independence, the first question asked of government was in 1893. This I picked up from an Indian Express article. 1891 or 1892, when Indian Councils Act was passed. It gave the legislature, it gave the member of a legislator, right for the first time that you can ask questions to the government. That means as a legislator, for the first time, power was given that you have the right to ask questions to the member of the government. The year was 1893. Absolutely correct statement. Number two, the presiding officers of the two houses, presiding officer of Lok Sabha is Speaker, presiding officer of Rajya Sabha is Vice President, Chairperson of Rajya Sabha. The presiding officers of the two houses, they are the final authority with respect to conduct of the question hour. This statement also is correct. Third statement is slightly tricky. Questions have to be limited to 150 words. And this statement also is correct. So which of the above statements are correct? D, all the three statements given are correct. But what sort of questions can be asked? Number one, it can be a starred question. Number two, it can be an unstarred question. There is also another type of question, that's what we call short duration question, but that's not too important for this exam. What is a starred question? Whenever this question is asked in 150 words, this question is differentiated by an asterisk mark. That means whenever a legislator is asking a question in 150 words, it's a starred question if it is characterized by an asterisk mark, which means that I need an answer to this question orally. Whoever asks this question, he needs the answer to this question orally. When the answer is given orally by a minister, that means you can ask supplementary questions as well. And that is what we call starred question. But if a question is unstarred, that means this question in 150 words, it is not differentiated by an asterisk mark, which means I need an answer to this question in written format. Let's say, for example, I'm the member of the parliament. I'm asking the question to the Home Minister. Please tell me, when are you implementing CAA 2019 in this country? If it's a starred question, he has to give me an oral answer. If he gives me an oral answer, I can ask supplementary questions as well. Another question, how many supplementary questions can be asked? And that number is 5. But if I'm asking a question to the Home Minister, and this question is unstarred, that means I need a written answer to this question. The Home Minister will get up and say The answer to this question is lying at your desk, which means it is an unstarred question. Let's look at something else. There is no question hour on the day President addresses MPs from both houses in the Central Hall. And this is what we call joint address of the Parliament or joint sitting of Indian Parliament. When is it that the President of India addresses both houses of the Parliament, members of both houses of the Indian Parliament in the Central Hall? Two instances. Instance number one, at the beginning of a year, normally when there is this budget session, at the beginning of a year, when the Parliament is convened for the first time, the first day is addressed by the President jointly, members of both Lok Sabha as well as Rajya Sabha. This is the first instance when President addresses the members jointly. And the second one is after the election. Election is over, new Lok Sabha has been convened. Now when the first sitting of this new Lok Sabha takes place, the President of India addresses the newly elected members from both Lok Sabha as well as Rajya Sabha at the Central Hall. And when this takes place, this presidential address takes place, there is no question hour. Number two, question hour is not scheduled either on the day the finance minister presents the budget. When the budget is presented every year on February 1st, that is the budget day when the finance minister presents the union budget. On this particular day also, question hour is not conducted. These two important statements may be asked in your prelims 2020. Let's look at something else. President's rule, and this is something that we discussed yesterday as well, but there is slight change here. President's rule can be imposed in a state only on the basis of governor's report suggesting breakdown of constitutional machinery. This statement is incorrect because under Article 356, President's rule can be imposed in a state on the report of the governor or even otherwise. That means even without the report of the governor, President's rule can be imposed in a state under Article 356 of the Constitution, which means that there is a breakdown of constitutional machinery in that state. Statement number two, President's rule can be revoked by the President on his own. Long story short, President of India is a mere rubber stamp. He does not have any powers of his own. He has to always act on the advice of the Council of Ministers, on the advice of the Prime Minister and his cabinet. He can't take any decision individually on his own. He does not have any discretionary power. So this statement is incorrect. He can revoke President's rule only on the advice of the cabinet, not on its own. Statement number three, without cabinet's recommendation, President's rule cannot be revoked by the President. This statement is incorrect because we have seen in Maharashtra, without a cabinet meeting, President's rule was revoked 5:45 a.m. in the morning. All these statements are incorrect. So D is the correct answer. None of these statements are correct. Why? What happened in Maharashtra? Rule number 12 or the Transaction of Business Rules 1961. This was invoked and this rule made it clear that even without cabinet's recommendation, President's rule can be revoked by the President on the advice of the Prime Minister without Prime Minister convening the cabinet meeting. And which extraordinary power was used? Rule 12 of Transaction of Business Rules. Let's look at something else. Assam Rifles, also in the news. Let's look at the question. Assam Rifles is tasked with maintenance of law and order in the northeast along with Indian Army, and it also guards the Indo-Myanmar border. Is this statement correct? Absolutely correct. Assam Rifles, it is a paramilitary force. It is the only paramilitary force with a dual control structure, and that is why it is in the news. There is a tussle between Ministry of Home Affairs and the Ministry of Defense. Because both these ministries, they control Assam Rifles, and that is why this controversy is in the news. It is the only paramilitary force with a dual control structure. This statement is correct. Third statement, slightly tricky. Assam Rifles is the most awarded paramilitary force in both pre- and post-independent India. This statement is also correct. So which of the above statements are correct? All these statements are correct. D is the correct answer. Let's look at something else. Anglo-Indian Reservation. The Parliament has decided by passing an act, by amending the Constitution, that now Anglo-Indian Reservation is over. What is this Anglo-Indian Reservation? If you look at Lok Sabha, if you look at Rajya Sabha, in Rajya Sabha, President of India has a power. What the President has to do? He has to nominate 12 members to Rajya Sabha. That means there have to be 12 MPs nominated to Rajya Sabha by the President from the fields of art, literature, science, social service. Those who have done exceptionally well in the fields of art, literature, science, social service, 12 of these individuals can be nominated by the President to the Rajya Sabha. One interesting question. Is it binding on the President to nominate 12 MPs to Rajya Sabha from the fields of art, literature, science, social service? Yes. Since we are talking about reservation in Parliament, Anglo-Indian Reservation, this can be asked in your examination. Is it mandatory? Is it binding on the President to nominate 12 MPs to Rajya Sabha from the field of art, literature, science, social service? Yes. But prior to this amendment, what was the procedure? 2 Anglo-Indians could be nominated to Lok Sabha. 2 Anglo-Indians. But it was not mandatory, it was not binding on the President to nominate 2 MPs to Lok Sabha from Anglo-Indian community. Constitution said, if the President of India is satisfied, if the President of India is satisfied that Anglo-Indian community is not sufficiently represented in Lok Sabha, if the President is satisfied that the Anglo-Indian community is not sufficiently represented in Lok Sabha, what the President can do, he can nominate 2 MPs from Anglo-Indian community to Lok Sabha. Here it was optional for the President. He may or may not have nominated. But here in Rajya Sabha, it was binding on the President. He had no other option but to nominate 12 MPs to Rajya Sabha from the fields of art, literature, science, social service. And now the government and the Parliament has decided to scrap this Anglo-Indian reservation. Now these 2 Anglo-Indians cannot be nominated to Lok Sabha. Let's look at something else. Which of the following statement or statements is correct about the office of the Speaker in the Indian parliamentary system? Statement number 1, he is appointed by the President for conducting all the parliamentary affairs. No. Speaker is elected. How is the Speaker elected? We need to understand Speaker's office also is in the news. Because the Speaker of Rajasthan Assembly, he petitioned the Supreme Court when there was this Sachin pilot controversy. So Speaker is in the news. Let's look at some of the important details regarding Speaker. Speaker is not appointed by the President. Speaker is elected. The Speaker of Lok Sabha is elected by the members of Lok Sabha. That too by simple majority. The Speaker of a Legislative Assembly is elected by the members of the Legislative Assembly, again by simple majority. So the Speaker is not appointed by the President. Statement number 2, he cannot vote for the resolution that seeks his removal from the House. This statement also is incorrect. What Speaker does? Speaker does not normally vote in Lok Sabha. The Speaker only votes in case there is a tie. What do we mean by that? Let's say, for example, there is this bill. This bill needs to be passed in the Lok Sabha. Those who are the proponents of this bill, their number is, let's say, 200. 200 MPs are in favor of this bill. 200 MPs are against this bill. That means in such a situation, there is a tie. When there is a tie, there is a deadlock. And to resolve this deadlock, the Speaker has a casting vote. And what is this casting vote? Which means the Speaker may either vote in favor of this bill or vote against this bill just to resolve this deadlock. That means normally Speaker does not vote in the first instance. Speaker only votes when there is equality of votes, when there is a tie. And to resolve this deadlock, the Speaker has a casting vote. But let's say, for example, I am the Speaker and I am to be removed by the Lok Sabha. For that, what is the procedure? The members of the Lok Sabha, they have to pass a resolution, but this resolution needs to be passed by effective majority. That means the Speaker of the Lok Sabha is elected by simple majority, but the Speaker is removed by effective majority when a resolution is passed by Lok Sabha. And when the resolution is introduced in Lok Sabha that I as the Speaker should be removed from the office, I will not preside over Lok Sabha. I will sit in a bench and there I will vote. That means in first instance, there I will vote because I am not presiding over Lok Sabha. That means I can vote for the resolution that seeks my removal as the Speaker. So this statement also is incorrect. He can resign by writing to the Deputy Speaker of the House. This statement is correct. That means Speaker resigns by submitting his resignation to Deputy Speaker. Deputy Speaker also resigns by submitting his resignation to the Speaker. So they resign by sending resignations to each other. Statement number 4, he vacates his office immediately whenever the Lok Sabha is dissolved. This statement is incorrect. That means when Lok Sabha is dissolved, all the members of the Lok Sabha, they will have to resign, except the Speaker. Speaker is the last person to resign. That is one of the significant feature regarding the office of the Speaker. So statement 3C is the correct answer. Let's look at something else. With reference to Leader of the House, consider the following statements. The Constitution of India envisages the Prime Minister to be the leader of the Lok Sabha. Constitution does not talk about leader of the Lok Sabha. Constitution does not talk about this post of the leader of the Lok Sabha. So this statement is incorrect. If Prime Minister is a member of Lok Sabha, he or she cannot be the leader of the House of Rajya Sabha. This statement is correct. Who is the leader of the House in Lok Sabha? Prime Minister. But it is not mentioned in the Constitution. It is mentioned in the rules and procedures of both houses of the Indian Parliament. Constitution does not talk about leader of the House. So who is the leader of the House in Lok Sabha? Prime Minister. But if Prime Minister is the member of Lok Sabha, for 10 years, Dr. Manmohan Singh was the Prime Minister of this country, but he was not the member of Lok Sabha. He was representing the state of Assam in Rajya Sabha. So he could not be leader of House in Lok Sabha. So when Dr. Manmohan Singh was the Prime Minister, Pranab Mukherjee was the leader of the House in Lok Sabha. It is only when Pranab Mukherjee became the President of India, after that Sushil Kumar Shinde became the leader of the House in Lok Sabha. But now since Prime Minister Modi is the member of Lok Sabha from Varanasi constituency, Prime Minister is the leader of the House in Lok Sabha. And who is the leader of the House in Rajya Sabha? A senior most minister nominated by the Prime Minister. Which means for 10 years, Dr. Manmohan Singh was the leader of the House in Rajya Sabha because he was the Prime Minister, he was also the member of Rajya Sabha. Let's look at something else. Another controversy and this time from the southern Indian state of Andhra Pradesh. What is the controversy? Andhra Pradesh Chief Minister, he has now decided that Legislative Council should be abolished in Andhra Pradesh. For that, please understand one thing. We have a bicameral legislature. That means two houses of the parliament. At the central level, we have Lok Sabha and Rajya Sabha. Bicameralism. At the state level also, there are some states which have two houses, Legislative Assembly and Legislative Council. The question can be asked, which of the following states have Legislative Council in India? Which are these states? Andhra Pradesh, Telangana, Maharashtra, Bihar, Uttar Pradesh, Karnataka. These are the only 6 states in India where we have a Legislative Council. It's also in the news because of Jammu and Kashmir. Jammu and Kashmir also had a Legislative Council, but that Legislative Council also has now been abolished. So there are only 6 states in India which have a Legislative Council. Interesting thing here is how these Legislative Councils are established. How these Legislative Councils are abolished. This is where questions can be asked in your prelims examination. Constitution has given the power that Legislative Council can be established, it can be abolished by whom? By the Parliament of India. That means Parliament of India has the power to establish a Legislative Council where it is not present, to abolish a Legislative Council where it is present. But what is the process? What is the process that is followed to create or abolish a Legislative Council? The process is, let's say for example, this is the Legislative Assembly of Andhra Pradesh. Andhra Pradesh has a Legislative Council. Legislative Assembly of Andhra Pradesh will pass a resolution. This resolution is passed by 2/3 of the members present and voting, which means special majority. That means Legislative Assembly of Andhra Pradesh passes a resolution by special majority and it requests the Parliament, please abolish the Legislative Council. That means what is the process of abolishing the Legislative Council where it is present? Legislative Assembly of that state will pass a resolution by special majority requesting the Parliament, please abolish a Legislative Council. But it is not binding on the Parliament. This resolution is not binding on the Parliament. This can be another statement in your prelims examination. Parliament may or may not abolish Legislative Council for Andhra Pradesh. But again, let's say for example, we are talking about Goa. Goa is a state where we don't have a Legislative Council. If the Legislative Assembly of Goa passes a resolution by special majority, then what will happen? This resolution will request the Parliament, please establish a Legislative Council. Again, this resolution is not binding on the Parliament. Parliament may or may not establish Legislative Council for Goa. This is the process. How Legislative Council is established and abolished in a state where it is present or where it is absent. But why should legislative councils be abolished? That's one important statement. That's one important factor that we have to take into account. Let's say, for example, here is Legislative Council, here is Legislative Assembly. Legislature has the task of making laws. Clear? Let's say, for example, there is a bill which originates in Legislative Council. If Legislative Council passes this bill is sent to Legislative Assembly. If Legislative Assembly also passes this bill, there is no problem at all. The bill is passed. But if Legislative Council passes a bill and this bill is rejected by Legislative Assembly, it is the death of the bill. That means this bill can never become a law. In case of Rajya Sabha and Lok Sabha, if one house passes a bill, the other house rejects a bill, in that case, what do we have? We have something called joint session of Indian Parliament. This joint session of state legislature is absent. It does not happen. There is no joint session of state legislature in this country. Very important statement for your prelims. That means a bill which originates in Legislative Council, if it is rejected by Legislative Assembly, that's the death of this bill. This bill will never become a law. Let's look at the reverse position. Legislative Assembly passes a bill. This bill is sent to Legislative Council. Legislative Council also passes this bill. There is no problem. The bill is passed. Legislative Assembly passes a bill. Legislative Council rejects this bill. That's one option available to Legislative Council. Legislative Assembly passes a bill. Legislative Council amends this bill. That's another permutation and combination. Legislative Assembly passes a bill. Legislative Council does not act on this bill. These are the only permutations and combinations. What we are trying to understand is the inferior role played by Legislative Council. When Legislative Assembly passes a bill, Legislative Council rejects this bill will go back to Legislative Assembly. Legislative Assembly passes this bill again, then this bill is sent back to Legislative Council. This time, even if Legislative Council rejects it, the bill is still passed. That means second time, Legislative Council cannot reject this bill. You can't block the law passed by the Legislative Assembly. Legislative Assembly passes a bill. It is then sent to Legislative Council. Legislative Council amends this bill. This bill will go back to Legislative Assembly. Now, Legislative Assembly is also adamant. I'm going to pass this bill again. I'm not even considering your amendments. This bill, when it's sent back to Legislative Council, this time, even if Legislative Council amends this bill second time, even then the bill is passed. That means you cannot amend this bill for the second time in Legislative Council. Your voice does not matter. Legislative Assembly passes this bill, then it is sent to Legislative Council. Legislative Council does not act on this bill. 3 months are over. This bill will come back to Legislative Assembly. Legislative Assembly is still adamant. It still passes the same bill again. And then Legislative Council says, I am also adamant. Again, Legislative Council is not acting on this bill at all. You will wait for 1 more month. And at the end of this 4-month period, the bill is passed in the same manner as it was sent by Legislative Assembly. That means the only power that is available to a Legislative Council is that it can block the bill sent by Legislative Assembly only for a period of 4 months. That means the only real power that is given to Legislative Council is that it can block the passage of a bill for a maximum period of 4 months. And these are very, very important statements for your prelims 2020. Clear? Let's look at something else. With reference to Delimitation Commission, consider the following statements. Delimitation Commission is a constitutional body. No, it is a statutory body. There is delimitation going on in the state of Jammu and Kashmir, and that is why delimitation becomes an important current affairs topic and can be asked in your prelims 2020. Delimitation Commission is not a constitutional body, it is a statutory body. Second, its orders have the force of a law and cannot be called in question in any court. This statement is correct. Why? Because we have Article 329 of the Constitution. And under Article 329 of the Constitution, courts are barred from interfering in electoral matters. That means courts cannot interfere in electoral matters. This is a ban on court by Article 329 of the Constitution. One such electoral matter is delimitation. So statement 2 is correct. The orders of the commission can be modified by Lok Sabha. Not possible at all. Although the report of delimitation commission is presented to the parliament, but neither Lok Sabha nor Rajya Sabha has the power to modify, amend the orders or the role of delimitation commission. So which of the above statements are correct? A, 2 only is the correct answer. Then there can be a tricky question. Tricky question in the sense, you might have heard of delimitation exercise going on in Jammu and Kashmir. But there are 4 other states where delimitation is going on simultaneously. Which are these 4 other states? These are 4 northeastern states. And you may be asked about these states in your prelims examination where delimitation exercise is being carried out. Which are these 4 states? Assam, Arunachal Pradesh, Manipur, and Nagaland. These are the 4 other northeastern states where delimitation is going on. Let's look at something else. Judiciary. And judiciary is in the news because of Ayodhya judgment, because of the new Chief Justice of India that we have, also because of the transfer of judges that has taken place. Let's look at topic number 1. Chief Justice of India names Justice S.A. Bobde as the successor. So you might be asked about the process that is followed in the appointment of the Chief Justice of India. So according to the current existing strength, according to the current standard that we use, outgoing Chief Justice of India names his or her successor. So when Justice Ranjan Gogoi was about to retire as the Chief Justice of India, he would name his successor. He named his successor Justice S.A. Bobde, and ultimately Justice S.A. Bobde was appointed as the Chief Justice of India. And normally the convention is that the outgoing Chief Justice of India names the senior most judge of the Supreme Court. The outgoing Chief Justice of India names the senior most judge of the Supreme Court as his successor, and then this successor is appointed as the Chief Justice of India by the President of India. Let's look at something else. Madras High Court Judge, Chief Justice V.K. Tahil Ramani, she was transferred. She was Chief Justice of Madras High Court, which is considered to be one of the most popular high courts in India. And she was transferred from Madras High Court to another high court, Meghalaya High Court. She thought that this is some amount of demotion. Why should I be transferred from a high court where we have 95 judges to a high court where we have only 3 judges? So this was considered as demotion, and ultimately she requested that her transfer should be put on hold. She should not be transferred, but this request was not accepted. And ultimately what she did, she dignified with dignity. She resigned from her office. But from this particular topic, what is it that you need to understand from the prelims examination perspective? Number 1 is, can a high court judge be transferred from one high court to another high court even against her will? Yes. How do we know about this? S.P. Gupta case, the year was 1981-82. And this is also what we call the first judge's case. And under this first judge's case, the Supreme Court said a judge of a high court can be transferred from one high court to another high court, even against her will. And that is what you need to understand from this topic. Not just this, Justice Akhil Qureshi, he was all set. The Collegium of the Supreme Court, and you would know the Collegium of the Supreme Court consists of Chief Justice of India and 4 senior most judges of the Supreme Court. That's what forms the collegium. And it is this collegium which recommends names to the president, that these judges should be appointed, these judges should be transferred. This collegium, it had recommended Justice Akhil Qureshi should be appointed as the Chief Justice of Madhya Pradesh High Court. But then the government did not allow it. Government more or less blocked it. And thereafter, Justice Akhil Qureshi was appointed as the Chief Justice of Tripura High Court. So since Justice Akhil Qureshi was in the news, since Justice Tahil Ramani was in the news, that is why this question can be asked in your prelims examination. Let's look at something else. What is the strength of the Supreme Court and the High Courts in India? Because there has been a change. Constitution says under Article 144, 124, the original Constitution said there shall be a Chief Justice of India and not more than 7 judges. This was the original Constitution of 1950. This Constitution said under Article 124 that there shall be a Chief Justice of India and not more than 7 judges. After that, we have increased the number of judges to the Supreme Court. But the question is, who has the power to increase the number of judges to the Supreme Court? Is this power given to President or is this power given to the Parliament? This power is given to the Parliament. That means in Constitution of India, the power to increase the number of judges to the Supreme Court is given to the Parliament. As of now, we have 34 judges. Because last year, the number of judges have been increased. So we have a Chief Justice of India. We have in total 34 judges in the Supreme Court. Since this number has gone up, that is why you can expect a question on this topic. When it comes to High Court, who gets to decide how many judges should be there in a particular High Court? This number is determined by the President of India. That means the strength of the Supreme Court is prescribed by the Parliament. The strength of a High Court is specified by the President of India. And how many High Courts do we have right now? We have 25 High Courts in India. So your Lakshmikant is not updated. It says 24 High Courts. We have 25 High Courts in India right now. Let's look at the Ayodhya verdict, which was given by a 5-judge bench of the Supreme Court in November 2019. Let's look at what this judgment was all about, because there are 2-3 important things that you need to know, which hopefully can be asked in your prelims examination. There was a dispute. Who is the real owner of this 2.77 acres of disputed land at Ayodhya? This was a dispute and long pending dispute. The year was 2010. Allahabad High Court gave an order. And Allahabad High Court said this 2.77 acres of disputed land should be divided into 3. 3 groups should be provided equal representation in this 2.77 acres of land. 1/3 of this land should be given to Nirmohi Akhara, the Hindu party. 1/3 of the land should be given to Muslim Waqf Board, the Muslim party. And 1/3 of this land should be given to Lord Ram or Ram Lalla, infant Lord Ram. And Lord Ram becomes juristic personality. This is where another interesting concept comes up, can be asked in your prelims examination. When we look at people residing within the territory of India, we may have citizens, we may have aliens. Citizens, aliens. Aliens are foreigners. Within these aliens, we have friendly aliens, we have enemy aliens. Who are these enemy aliens? The citizens of those countries which are at war with India. As of now, is India at war with any other country? No. We are in a proxy war with Pakistan. We are in an undeclared war with China, but war is always declared. Neither has India declared war on China, nor has China declared war on India. So even the Chinese citizens in India, they are friendly aliens. Then there is third concept, juristic personality. This juristic personality is somebody who is treated as a person by law. Since the law treated Lord Ram as a person, Lord Ram becomes a juristic personality. That's statement number one. But then this Allahabad High Court verdict of 2010, it was challenged in the Supreme Court, and now in 2019, finally this Ayodhya judgment has been delivered. And what Supreme Court said? The entire 2.77 acres of disputed land should be given to Lord Ram. Lord Ram is the owner of this 2.77 acres of land. That means Nirmohi Akhara was not given any land. Muslim Waqf Board was not given any land. The entire disputed land was given to Lord Ram. But how did Supreme Court reach to this conclusion? This cannot be asked in your exam, but one concept related to this can be asked, and that is preponderance of probabilities. So you might be asked, preponderance of probabilities is the term recently seen in the news, and it is related to which of the following? Is it related to privatization of airports? Is it related to India-China dispute over line of actual control? Is it related to Ayodhya judgment? So it is related to Ayodhya judgment. What is this preponderance of probabilities? Let me tell you very briefly about this. To resolve this Ayodhya dispute, the court looked at what is the position from 1526 or 1528 till, let's say, 1856-57. That means this is one period. Then there is another period from 1856 to 57 to 1934. And then there is 1934 onwards. 3 periods. 1526-28 till 1856-57. Why this period? It was argued that Mir Baqi, who was the military commander of Babur, who laid down Mughal Empire in India, either Mir Baqi on his own or on the directives of Babur, Babri Masjid was constructed at Ayodhya in the year 1528 or 1526, whatever the case may be. And then from this period to 1856-57, Muslim side, when I'm talking about Hindus or Muslims, I'm not talking about communities, I'm talking about those who were the litigants in this case, Muslim side, Hindu side. In this case, the Supreme Court said, look at the probability. The probability is that throughout this period, the Hindu side, it has more probability that the Hindu side was the owner of this 2.77 acres of land. Why? Because during this period, 1528 to 1856, Muslim side has not been in a position to convince the judiciary that we were holding this piece of land, or we were holding this piece of property, or we were offering namaz or prayers in the Babri Masjid. Something happened in 1856, and this is where link history with current affairs. Lord Dalhousie, he had a policy, doctrine of lapse. Under doctrine of lapse, what was the objective of Lord Dalhousie? If there is a ruler of a particular area, but this ruler does not have a male heir, what will happen? The British will control that state. And that is how Jhansi and other areas were annexed by the British. That's what we call doctrine of lapse. Awadh was also annexed during Lord Dalhousie's term. But Awadh was not annexed under doctrine of lapse. Awadh was annexed under mismanagement. So Lord Dalhousie said it was the mismanagement by the rulers of the Awadh, and that is why we want to annex Awadh. And this became one of the significant reasons for the revolt of 1857. A massive revolt broke out in the northern and central part of India and nearly swept away the British rule. And one big reason for that was the annexation of Awadh by Lord Dalhousie, but not because of doctrine of lapse, but because of mismanagement, because of misrule, or what we can call maladministration. And then what happened? It was in this year 1856-57 that there were some clashes between the two groups, Hindus and Muslims, in Ayodhya, and that is how some sort of compromise was reached. The inner side, the Muslims would pray. The outer side, the Hindu side would also pray, would also pay obeisance to the deity. And then this period, 1856 to 57 to 1934 was considered. And in 1934, there was a riot. And in this riot of 1934, one of the dome of Babri Masjid was also demolished. And then it was repaired by the British government, by the British administration. But at that time, the court looked at, the Supreme Court in 2019, it looked at what is the probability. Which side claims this entire land? The probability is that the Hindu side is the real owner of this land. Why? Because Muslim side could not convincingly prove that they were offering namaz or prayers during this period, but Hindu side was consistently praying. They looked at various articles written, various journals written during that time, and came up with this conclusion that Hindu side consistently controlled this land, or they revered this land and considered this land as the birthplace of Lord Ram. And that is what we call preponderance of probabilities. And this preponderance of probabilities normally is used only in civil cases, such as this land dispute is not used in a criminal case. This preponderance of probabilities can be asked in your prelims examination. Let's look at something else. Doctrine of adverse possession. This was also part of the Ayodhya judgment. What is this doctrine of adverse possession? Let's say this is the piece of land. This is not my land. I'm not the owner of this land, but I am possessing this land. I have captured this land and I'm using this land. If I'm using this land for 12 years and my possession of this land is continuous, my possession of this land is uninterrupted, my possession of this land is peaceful, the real owner of this land is not claiming this land, in that case, doctrine of adverse possession can be used and I can be called the owner of this land. This was something projected by the Muslim side of Ayodhya dispute. They said you can use this doctrine of adverse possession and give us the possession of this 2.77 acres of disputed land. Since we have possessed this land continuously for more than 12 years, give us this land. But the Supreme Court said it does not apply in your case. Why? Although you possessed it, but it was not continuous. It was not uninterrupted. And in any case, it was not peaceful. That means this doctrine of adverse possession could not be used in this case. This can be also asked in your prelims examination. Let's look at something else. Places of Worship Special Provisions Act of 1991. Why is this in the news? Because it is mentioned in the judgment as well, in the Ayodhya judgment as well. This law was passed in 1991, and this law of 1991 says one thing. Whatever the status of a religious place was at the time India got independence, that means on 15th of August 1947, what was the status of a religious property that we have to retain? We can't convert the status of that religious place, that place of worship. And that law is Places of Worship Special Provisions Act of 1991. But then how was the status for Ayodhya changed? Because in 1947, there was a Babri Masjid. The reason for that is Ayodhya was an exception. The disputed land at Ayodhya was an exception. It was not included in this 1991 law. Long story short, a law was passed in 1991. According to this law, what was the status of a religious place on 15th of August 1947 that needs to be retained? But there was one exception created, Ayodhya. Why? Because even at that time, there was a dispute on this disputed 2.77 acres of land. Two more things and this topic is over. One is Article 142 What is Article 142? And this Article 142 was used in favor of Muslim Waqf Board as well as Nirmohi Akhara. Under Article 142, Supreme Court has an extraordinary power. Under Article 142, Supreme Court can issue any order so as to give complete justice. This question was once asked in your prelims examination. You never know, maybe once more this question can be asked. Under Article 142, Supreme Court can issue any order so as to give complete justice. And this Article 142 was used in the Ayodhya judgment for two parties, Muslim Waqf Board and Nirmohi Akhara. How? Muslim Waqf Board was given 5 acres of land at a prominent location in Ayodhya. Muslim Waqf Board lost the case. The entire 2.77 acres of land was given to Lord Ram. So how can more than 2.77 acres, close to double that amount of land, be given to Muslim Waqf Board? Because Supreme Court said complete justice can be given only if 5 acres of land at a prominent location in Ayodhya will be given to Muslim Waqf Board. Why? Because they lost their place of worship. They lost a mosque. And we can give complete justice in this case if 5 acres of land is awarded to them. Not only for Muslim Waqf Board, even for Nirmohi Akhara. Because in 2010, the judgment was 1/3 of this land be given to Muslim Waqf Board, 1/3 of this land be given to Nirmohi Akhara, 1/3 of this land be given to Lord Ram. But this 2019 judgment gave the entire 2.77 acres of disputed land to Lord Ram. And Nirmohi Akhara, its claim was dismissed by the Supreme Court, but Supreme Court used Article 142. Supreme Court said, tomorrow, when you are setting up a trust, and this trust will construct a mega Ram temple at Ayodhya, you will have to give prominence to the member of Nirmohi Akhara. Despite the fact Nirmohi Akhara lost the case, but they were provided special place in this trust which is constituted to construct the temple at Ayodhya. Article 142. Another question, in the context of Indian Constitution, which one of the following would you accept as the most appropriate definition of secularism? Statement 1, freedom of citizens to live by their religious beliefs. Individually, this statement is correct. But is this the definition of secularism in India? Let's see. Statement number 2, separation of religion from the state. This is genuine definition of secularism, but in the West. After the Renaissance period, church was separated from the state, and that is what they called, the West called, the Europe called secularism. But we are talking about in Indian context. Let's wait and watch if B is the right answer. C, absence of communal disharmony. How I wish there would be absolute absence of communal disharmony. That's clearly not the answer. D, equal protection by the state to all religions. That is the definition of secularism in Indian context. That means in the context of Indian Constitution, which one of the following would you accept as the most appropriate definition of secularism? That is equal protection by the state to all religions. And that is it that we had to discuss regarding the Ayodhya judgment. And I think we will end it here. We'll meet again tomorrow, 7:30 p.m. and we will discuss current affairs related to international relations. We couldn't complete the entire slide, but doesn't matter. We will complete it next time when we will meet and discuss lecture number 3 of polity-based current affairs. But before we leave, please do not forget to like this video, comment favorably as well, subscribe to our channel if you haven't, and if you're liking our initiatives, give us a thumbs up. See you tomorrow, same time. Bye-bye.